Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm confused on behalf of the club.
First, state your name, please.
I'm George Styron II.
All right. This date and time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines as well.
You can feel the tension. The judge lays out every single charge, and they're not small ones. And then she tells him straight. If he's going to represent himself, he's playing by the same rules as an attorney. No safety net.
Chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the new staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first day.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time evidence to even review it, to be able to articulate it.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
Right. I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, a count of felonious assault, which is assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. Right.
The part gets messy. He's saying he hasn't had enough time to even watch the body cam videos that could decide his future. Imagine going into a fight without ever seeing your opponent's moves. That's how he's framing it.
Instead of me being able to address what I got going on internally and at a hospital or outside in the world, I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the jail would hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond. for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to amend the information I had serious charges against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howe took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. I said it meant legally to the courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, he was sitting there for a welfare check with a possible wrong domestic, which led me being pulled over, me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who he was looking up in his talent or the legal system or whatever it is they use in the police cruiser. Make sure to iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. Also, I was the one who stayed on top of these charges. I'm the one who called the court every day.
And here's the curveball. The prosecutor isn't just fighting his release. They're stacking more charges on top. Felonious assault gun charges, and even an alleged threat against the sergeant's dog. This is the moment the stakes shoot way up.
Stayed on top of this case, and I'm the one who arranged the court date with Miss Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. I had no intentions of running or trying to avoid it at all. And I think my actions were such.
In this matter, I'm not going to, at this point, change your bond, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you I could trust.
He's not taking that lying down. He insists the word cook meant going after someone in court legally, not physically. And he tries to paint himself as someone who's been pushing for justice from the start, not hiding from it.
Courtroom. I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration.
Listens, but she's not swayed. She makes it crystal clear public safety comes first. Bond denied, and you can see in her tone she's already made her mind up for today.